Our goal here is to just strip away all that dense legal jargon, figure out what SIJ actually is in simple terms, and map out this massive administrative backlog that's honestly paralyzing the whole program. Let's get to it. To really understand how this system works, we first have to ask a pretty tough question. What exactly happens to immigrant kids facing deportation when sending them back to their home country is fundamentally unsafe? We're talking about youth who have survived parental abuse, abandonment, or severe neglect. If they end up in removal proceedings, what legal tools actually exist to protect them from being sent right back into harm's way? Well, the foundational concept behind SIJ comes straight from international humanitarian law. It all boils down to the best interest of the child. This is a globally recognized principle designed to protect the most vulnerable among us. When Congress created the SIJ framework, the whole idea was to integrate this humanitarian best interest standard into what is otherwise a very rigid U.S. immigration system. So, let's unpack that humanitarian promise and look at the what and the why of this program. In really simple terms, SIJS is a promise from the U.S. government. Originally created back in 1990, it offers a pathway to a green card for children who have survived parental maltreatment. If you are unmarried, under 21, physically present in the U.S., and you need a juvenile court's protection because you literally cannot be safely reunified with your parents, you are exactly who this status was designed to protect. Now, because family welfare isn't really a federal issue, the process is a unique two-step dance. First, a local state juvenile court has to step in. A state judge officially declares that the child cannot be safely returned to their parents and that going back to their home country is not in their best interest. Only after getting that state court order does the youth move to step 2, which is filing a federal petition with U.S. Citizenship and Immigration Services, or USCIS. But here is where things get really complicated. We need to talk about the visa backlog. You think an approved petition means a green card is on the way, right? Not exactly. Right now, there are over 100,000 youth who did everything right. They went to state court, they proved their extreme vulnerability, and USCIS approved their petitions. But they're currently trapped in this massive, years-long visa backlog. Over 100,000 kids just stuck in legal limbo. So why the huge wait? Well, imagine getting a VIP ticket for your approved humanitarian petition, but when you show up, the venue door is strictly capped by employment-based visa limits. It's wild, but even though SIJ is a child welfare program, Congress categorized these visas under the employment-based fourth preference, the EB4 category. By law, this category only gets 7.1% of the worldwide allotment of employment visas. Demand vastly exceeds that tiny quota, leaving kids locked outside for years. And it's exacerbated by a bureaucratic nightmare called retrogression. Basically, the line moves backward because of the high demand and strict caps. As of mid-2026, youth who filed their approved SIJS petitions way back in 2021 and 2022 are only just now becoming eligible for visas. We are talking about a 4 or 5 year wait without permanent legal status before they can even move forward. To survive that agonizing multi-year wait, the government created a temporary shield. But lately, that shield has completely fractured. A vital tool here is something called deferred action. Let's translate that legal jargon. It just means the government agrees to temporarily hit pause on any deportation efforts. Crucially, it lets these waiting youth get a work permit. For a teenager trying to graduate high school or pay for college, this means getting a social security number, a driver's license, and avoiding exploitative, dangerous labor while they wait in that massive visa line. But this policy has given everyone severe whiplash. In 2022, youth were automatically considered for deferred action once their SIJ petition was approved. Then, in June 2025, USCIS abruptly rescinded the policy. That sparked intense federal court interventions in early 2026, and eventually, highly restrictive new rules officially took effect in May 2026, aligning with the Trump administration's enforcement priorities. The real game changer happened on May 10, 2026. Before that date, USCIS automatically looked at your approved SIJ case and considered you for protection. After May 10th, that automatic protection from deportation and access to work permits for newly filing youth is officially gone. USCIS simply won't do those automatic determinations anymore, leaving thousands highly exposed. And this leaves absolute chaos for anyone caught in the middle. For youth whose petitions were approved during that messy litigation window of the ACRV Noam lawsuit in mid-2025, USCIS's standards remain incredibly confusing and contested in the courts. Even when deferred action is on the table, it is absolutely no longer the guarantee it once was. Which brings us to a really stark reality. What actually happens to these youth who are fighting removal in court, but no longer have deferred action to protect them? Historically, immigration judges would use a tool called administrative closure. Basically, they just take the case off the active trial calendar. The judge would say, look, we know you're waiting in a 5-year line for your visa, so let's just pause this court case and let you wait safely. However, recent strict rulings from the Board of Immigration Appeals, like the Cahuic Talam and Penzon Rozo decisions, have shattered that practice. The courts ruled that judges can no longer pause cases just because a youth is waiting in a long visa line. They cited the indeterminate and likely lengthy period of time before the youth can actually get their green card. Legal experts are calling this a three-way squeeze on SIJ youth. Let's add it up. There's no automatic deferred action shield. ICE is aggressively ramping up enforcement, and courts are actively refusing to pause deportation proceedings. These 100,000-plus youth now face a terrifying gauntlet of enforcement, mandatory no-bond detention, and potential deportation despite having a U.S. government-approved humanitarian petition. So I want to leave you with this final thought to ponder. The SIJ program was built on the fundamental principle of protecting the best interests of abused and abandoned kids. But as this backlog keeps growing and the legal tools to protect these children completely vanish, how can the original humanitarian promise of this program possibly survive?